formal objection and opposition to the transfer of detainees to Rwanda. Dated April 28, 2026, addressed to the Secretary-General of the United Nations, the Presidency of the International Residual Mechanism for Criminal Tribunals, and the members of the United Nations Security Council. We, the children and families of detainees serving their sentences under the jurisdiction of the International Residual Mechanism for Criminal Tribunals in Benin, Niger, and Senegal, speak today. We express our strongest, absolute, and unconditional opposition to any decision aimed at transferring our parents to the Republic of Rwanda. This opposition is not conditional. We do not call for further evaluation of the security or judicial situation in Rwanda. We affirm, on the basis of uncontested legal arguments and documented facts, that Rwanda cannot, under any circumstances, constitute an acceptable option. This letter complements the memorandum written by the detainees themselves on April 6, 2026. We add the voice of the families and concrete alternative proposals. Part 1. Legal arguments. The transfer is illegal under international law. The principle of double jeopardy. First, there is a violation of the principle of ne bis in idem. Almost all of our parents have already been judged in absentia by the Gacaca courts in Rwanda. A transfer would not be a simple change of location. It would amount to the execution of parallel judgments. This would result in the same individuals being punished twice for the same acts. This principle is strictly prohibited by the International Covenant on Civil and Political Rights, as well as by the statute of the tribunal itself. The risk of inhuman treatment. Secondly, the transfer would violate the principle of non-refoulement. International jurisprudence, notably the Soering judgment of 1989, prohibits transferring a person to a country where they risk inhuman treatment. This principle was reinforced by the Othman judgment in 2012. Rwanda, whose judicial reliability is seriously contested, cannot guarantee the absence of torture. The right to a fair trial. According to the Babar Ahmad judgment, it is mandatory to independently assess detention conditions before any transfer. However, Rwanda is both the requesting country and the destination country. It is structurally incapable of providing an independent evaluation of its own guarantees. Any decision based solely on its assurances would be legally invalid. Detainees. Finally, Rule 59 of the Nelson Mandela Rules states that any transfer must take place only with the informed consent of the detainee. 13 detainees formally and publicly refused this transfer in their memorandum dated April 6, 2026. Ignoring this refusal would constitute a direct violation of international commitments. Violation of dignity and humane treatment. The directive of the mechanism, dated May 7, 2025, conditions any transfer on respect for fundamental rights, including dignity and humane treatment. Documented violations in Rwanda make such compliance impossible. Precedent of the International Criminal Tribunal for the former Yugoslavia. In its established practice, this tribunal systematically refused to transfer convicted persons to states involved in the conflict. No Serbian detainee was transferred against their will to Bosnia and Herzegovina. The same principle applies here. Rwanda is directly involved in the conflict that led to these prosecutions. The mechanism, as successor to these tribunals, is bound by this precedent. The principle of impartiality. The Pinochet case established the international obligation not to facilitate impunity for serious crimes. Transferring detainees to Rwanda would eliminate potential witnesses and prevent any future revision of judgments. This would make the United Nations complicit in one-sided impunity. Part 2. Political and factual arguments. Rwanda represents a documented threat, a structural conflict of interest. Rwanda is not a neutral third-party state. It is directly involved in the events that led to these prosecutions. Its government has fabricated false testimony and blocked investigations into crimes committed by the Rwandan Patriotic Front. Entrusting detainees to such a state would validate this impunity. Official ideology and direct threat. President Kagame publicly declared that even those who did not commit crimes must ask forgiveness for those who did. This creates a concept of collective and hereditary guilt. Families and children are therefore targeted by association. He also declared that, if necessary, a hammer would be used to kill a fly. Such statements represent direct threats. The Niger precedent. Individuals relocated to Niger in December 2021 were expelled only 22 days later under diplomatic pressure. This demonstrates Rwanda's ability to influence third-party states. Regional instability. Rwanda is accused of supporting the armed group M23 in the Democratic Republic of the Congo. Such involvement raises serious concerns about stability and reliability. Human rights violations. Reports from Amnesty International and Human Rights Watch document extrajudicial executions, enforced disappearances, arbitrary detention, and torture in secret detention facilities. These violations are ongoing and systemic. The right to truth. The detainees hold important information about events of 1994. A transfer to Rwanda, where alternative narratives are restricted, would permanently prevent access to this truth. The essential role of the African Union and African states. A. The African Union, under the Burundian presidency Burundi, currently holds the presidency of the African Union. This represents a major diplomatic opportunity. Burundi, which has direct knowledge of the threat posed by the Rwandan regime to regional stability, is in a position to exercise decisive influence. We call on the African Union to take a formal position against the transfer of detainees to Rwanda and to support the continuation of existing arrangements in Benin and Senegal. A decision affecting African nationals on African soil cannot be taken without the voice of the African continent. B. The Democratic Republic of the Congo and Burundi. The Democratic Republic of the Congo is directly affected by Rwanda's military involvement through its support of the armed group M23. Burundi continues to face a persistent threat. These two states have a direct and legitimate interest in opposing any decision that would strengthen the position of Rwanda. We therefore call upon their delegations within the United Nations and the African Union to support this position. C. Benin and Senegal. Benin has hosted detainees since 2009 and Senegal since 2017. Both states have demonstrated their capacity to fulfill this responsibility in full compliance with international standards. Their role should be recognized, supported, and strengthened rather than replaced. 4. The human impact on families, a collective penalty. Beyond legal and political considerations, this decision has a direct and profound human impact. The refugee status of many members of our families would be compromised. This protection was granted precisely because of the risks of persecution associated with the Rwandan regime. Requiring families to engage with this regime in order to maintain contact with their relatives would undermine that protection. Our parents are elderly detainees, and many suffer from serious health conditions. A transfer would pose a direct risk to their well-being. For the vast majority of families, Such a transfer would mean the definitive end of visits and permanent separation. The official ideology of collective responsibility exposes families, including children and future generations, to risk. Relatives already living in Rwanda face pressure and persecution. We therefore urge international authorities not to impose a collective punishment on innocent families. Concrete alternative solutions. We propose viable, immediate, and legally grounded solutions. First, the continuation of detention in Benin and Senegal. These arrangements have functioned for years. Agreements are in place and infrastructure exists. It would be unreasonable to compromise the safety and fundamental rights of detainees for limited financial considerations. Second, the release of eligible detainees. A significant number qualify for early release if restrictive conditions, such as the requirement of admission of guilt, are removed. Third, the designation of a neutral third state, a state with no connection to the conflict, capable of guaranteeing judicial independence and respect for fundamental rights, would be an acceptable alternative. Fourth, the transfer of administrative control to current host states. While maintaining judicial supervision by the mechanism, this option would preserve existing safeguards. 6. Conclusion and formal requests. We respectfully request the immediate and definitive removal of Rwanda from any list of host states, the suspension of all preparatory measures for transfer, the continuation and strengthening of existing arrangements in Benin and Senegal, the revision of the directive on early release, the removal of the requirement of admission of guilt, the formal position of the African Union against the transfer, the mobilization of concerned states, the consultation of detainees and their families in any future decision, the involvement of United Nations mechanisms for an independent review, the consideration of this letter in all relevant decisions. International justice must not become complicit in decisions that expose individuals to serious and irreversible risks. Rwanda is not an option. It cannot be one. We rely on the responsibility and conscience of the relevant authorities. Signed, the families of detainees of the International Criminal Tribunal for Rwanda and the International Residual Mechanism, dated April 28, 2026.